You see it on the news all the time, right? Armed conflict. But behind all those headlines, there's this incredibly complex web of rules that's supposed to govern even the most brutal wars. So, what exactly are these rules? Who even makes them? And, in the heat of battle, do they really matter? Well, let's dive in and find out. It's easy to think that once war breaks out, it's just total chaos, that all the rules go right out the window. But believe it or not, international law has a lot to say about that. There's an entire legal framework built up over centuries that's designed to bring at least some measure of order and humanity to the battlefield. To get your head around this, the law basically splits the whole problem into two big questions. First, you've got just ad bellum. That's just Latin for the law on going to war. It asks the big question: when is it even legal for a country to use military force in the first place? And then there's jus in bello, the law in war. This part covers how a war has to be fought once it's already started. And this separation is absolutely crucial. It means that even if a country starts a war illegally, the soldiers on all sides are still required to follow the rules of conduct. It's kind of like saying, even in the worst possible moments, there are still lines you can't cross. Okay, so here's our game plan. First, we're going to talk about this big, kind of radical idea of banning force altogether. Then, we'll look at the two major legal exceptions, getting the green light from the UN Security Council and the right to self-defense. After that, we'll get into the real nitty-gritty, the rules of engagement on the battlefield. And finally, we'll wrap up by asking the big question: is this whole system actually fit for the modern world? All right, let's start at the very beginning. After the absolute, unimaginable horror of World War II, the international community got together and did something truly audacious. They tried to outlaw war itself. And the cornerstone of this whole new world order is the United Nations Charter. It was signed back in 1945 in San Francisco, and its main purpose was to, quote, save succeeding generations from the scourge of war. I mean, this is a document that was literally born from the ashes of global conflict, driven by this profound hope for a lasting peace. And this right here, this is the heart of the whole system. Article 2, Paragraph 4. It's a general ban on force. And notice the wording here, it's really specific. It doesn't just outlaw the use of force, but also the threat of force. What that means is a country can't just, say, park its navy off a neighbor's coast to intimidate them. That action, in and of itself, is a violation of international law. Now, what exactly counts as force? Well, lawyers have debated this for decades, but the general agreement is that we're talking about military force. Armies, navies, air forces. So things like tough economic sanctions or cutting off diplomatic ties, while they're definitely hostile, they don't count as force under this specific rule. Oh, and it's also worth pointing out that if a country actually invites another nation's military onto its territory, maybe for joint training or to help fight a common enemy, that's totally fine because there's consent. But, the people who wrote the charter, they weren't naive. They were realists. They knew a complete ban was maybe a bit too idealistic, and that sometimes force might be the only option left. So they created a system to control it. And at the very center of that system, they put one very powerful group, the UN Security Council. So the charter basically gives this 15-member council the main job of keeping the entire world peaceful and secure. But the real power, well, that lies with the 5 permanent members: China, France, Russia, the UK, and the US. Why? Because each one of them holds a veto. And that veto power is massive. It means that if just one of those 5 countries says no, a resolution is dead in the water, even if every other country in the world supports it. It's a system that gives a tremendous amount of power to a very small club. And this is basically the Council's playbook, and it's designed to escalate things gradually. So step 1, it has to officially decide that a situation is a threat to the peace. If it does, the next step is usually to call for everyone to calm down, demanding a ceasefire. If that doesn't work, the Council can bring out the bigger guns, but not military ones yet. We're talking sanctions, travel bans, arms embargoes, and only when all of that has failed, as a total last resort, can the Council authorize member states to use all necessary means, which is basically UN speak for military force. Okay, but what if a country gets attacked right now, and they don't have time to wait for the Security Council to have a bunch of meetings and pass a resolution? Well, that's where the second big exception to the ban on force comes into play: the inherent right to self-defense. Article 51 is the key. It says, flat out, that every country has an inherent right to defend itself if it's the victim of an armed attack. It's a fundamental right that exists before you get any permission slip from the Security Council. But, and this is a big but, The country has to immediately tell the council what it's doing, and that right to self-defense only lasts until the council itself steps in to handle the situation. But this right is not a blank check. For an act of self-defense to be considered legal, it has to pass 3 big tests. First, there has to be a genuine armed attack. We're not talking about a small border skirmish. This has to be something serious, like a full-on invasion. Second, the use of force has to be a necessity, which means there were no other reasonable, peaceful options left on the table. And third, the response has to be proportional. You can't use a nuclear weapon to respond to a few shots fired across the border. The defensive action has to be in balance with the scale of the initial attack. And this is where a rule book written for a world of nation-states with big, conventional armies starts to get really, really complicated. I mean, what happens when the threat isn't coming from another country's military, but from a shadowy terrorist group that's operating from inside its borders? Or what if you have solid intelligence that a devastating attack is about to happen? Do you really have to just sit there and wait to get hit first?
So these are the 2 biggest gray areas today. When it comes to non-state actors, the 9/11 attacks were a real game changer. Afterwards, the Security Council actually affirmed America's right to self-defense against al-Qaeda. This basically paved the way for something called the unable or unwilling doctrine. The argument goes that if a country is hosting a terrorist group and either can't or won't stop them, then the country that's being threatened has a right to go in and deal with the threat itself. Then you have anticipatory self-defense. Article 51 says an attack must occur, but there's a growing, though still very contested argument that you don't have to wait for the first blow if an attack is truly imminent. Of course, the huge debate is, what does imminent actually mean? Okay, so we've covered the rules for starting a war, but what about the rules inside a war? This is where we shift from the question of when to the question of how. And now we're diving into a different area of law called international humanitarian law, or IHL for short. This whole branch of law is basically about damage control. It's super pragmatic. It accepts the brutal, awful reality that wars are going to happen, but it tries to set some ground rules to limit the suffering. It's all about protecting civilians, caring for the wounded, treating prisoners of war with dignity, and just ensuring that even in the middle of all that chaos, there is a baseline of humanity that has to be respected.
Historically, these rules kind of grew up along 2 main tracks. An easy way to think about it is one stream protects people and the other regulates weapons. So you have Geneva Law, named for the city where the main treaties were signed. That's all about protecting people, the victims of war, like the wounded, shipwrecked, prisoners, and of course, civilians. Then on the other side, you have Hague Law, which focuses more on the tools and tactics of war, what kind of weapons are illegal, and what methods of fighting are simply off-limit. The Geneva Conventions really are the absolute bedrock of all humanitarian law. This set of 4 treaties, which were updated in 1949, have been signed by pretty much every single country on Earth. That makes them truly universal. Each one protects a different group of vulnerable people caught in a conflict. And they've been updated over the years with what are called additional protocols to try and keep up with how modern warfare is changing, from civil wars to new technologies.
So, we've looked at the rules for starting a war and the rules for fighting one. It's this complex, really ambitious system that's designed to put some limits on our worst impulses. But all of this just leads to one huge nagging question. Does any of it actually work? And that right there is the massive debate that's happening today in foreign ministries, in universities, and in courtrooms all over the world. When the most powerful countries on the planet can just use their veto to block any action they don't like, is the system really fair? When the rules that were written back in 1945 are struggling to deal with new threats like cyber warfare and killer robots, is the system still fit for purpose? There are no easy answers here, and it's a profound question that really affects the security of every single one of us.